Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening, and welcome to another Ask the Expert show. This is the first Thursday of the month. Without a doubt, my favorite show to do. This is our community association show. We have the Kaye Rembaum law firm, who's probably been with us for 4 or 5 years. It gets more calls, more emails than any other show. If you live in a condo, if you are in an HOA, if you're a board member, you'd like to give us a call, we have board certified Robert Kaye, one of the senior partners. Let me give you the phone number here. It's 888-565-1470. 888-565-1470. Let me welcome from Portland, Oregon, Robert Kaye.
Hello, everybody.
Yes, that's Kaye Rembaum. How did you get your name first?
I was there first.
Oh, that makes sense. So Rembaum couldn't argue with you, right?
No, he could not.
Listen, it's always so great to have you on the show, and oh my gosh, we were just talking before the show. We have had so many people contact us, after this horrible thing that happened in Surfside. And we'll be getting to some of those questions. But a lot of people are concerned about their buildings.
Well, it's
and their reserves, Robert. Let me say also, and their reserves, too.
Well, that's, I think, more concerning than anything else is the lack of funding of reserves, because I think most buildings routinely will present to the owners every year a reduction or a waiver completely of the necessary reserves, and the owners intend to put off the funding of this on a regular basis, and that will leave them in a situation when the need arises of having to do a special assessment or seeking funds from another source, such as a bank on a long-term loan. It's horrific what's happened in the building that collapsed down in Surfside, but it's important to note that that's not going to happen everywhere.
Right.
It's a very unusual circumstance. We don't know the cause of it yet, but it's not like every building's about to collapse. And I know that it's disconcerting that if it happened once, it could happen again. But it's important for all of these buildings to be inspecting their components on a regular basis. And certainly there's a big push to do that now everywhere. And I think that we're going to see a lot of that. We could be seeing changes in the legislature next year for reserve issues. There was a provision in the condominium law several years ago that required reserve studies updating every 3 to 5 years, and that was taken out of the statute some time ago, thinking, well, the government doesn't need to tell people what to do, and they took that out. So whether or not that was right or wrong, it doesn't matter. It is what it is, and at this point, if the legislature wants to put it back in next year, that's something that they could consider.
If you have a question, if you live in an HOA or if you live in a condo association, if you're a board member or management team, give us a call here. We've got Robert Kaye here from Kaye Rembaum, 888-565-1470, and he'll be more than happy to answer your questions. A lot of people wanted to know if there's any way that the governor can move up this have an emergency because nothing is supposed to happen till next year. Is that correct?
Right. Our legislature meets only one time a year unless there's a special session called by the governor. And that, I believe, next year is going to be early in the year, prior to March or in March. I forget exactly the timing of when it's supposed to start next year. Since there may be some primary elections, they may be doing it earlier next year than normal, so it could be January, February time, but in any event, not until 2022. Whether or not there's a need for emergency legislation at this point I can't really say. I mean, especially without knowing what exactly happened at that building, it's unlikely to see an emergency session called on something like that. But I'm sure there are currently already bills being drafted, various places around the state to present to the legislature next year.
There was, we had about 3 or 4 people ask if board members were paid. Do you think they could get better people to be on the board? What are your thoughts?
Well, I think that it's hard to really say. I mean, if there's a requirement that a board member be an owner within the community, then your pool of potential board members is limited to who that is. So regardless of whether you pay them or not, you still have the same group of people that are serving on the board. And paying board members doesn't necessarily guarantee that they're going to be more capable than otherwise. So if you open up your board to outsiders and you're hiring more, I guess, expert individuals with the background needed to be there, and then you're paying a significant sum, that's a different issue, a different situation. It becomes basically a business organization just in operating from the board perspective, which is traditionally not how condominiums are structured.
If you have a question for Robert Kaye here, give us a call at 888-565-1470. That's 888-565-1470. We usually start off the show you telling everybody about your firm. Kind of skipped over that. So I really like to go back to, because there's always new people tuning in for the first time. Tell people about what your firm does.
Well, Kaye Rembaum is a full-service firm, but primarily specializing in the area of community association representation, condominiums, homeowner association, cooperatives primarily, and handling all facets of the day-to-day legal needs of community associations. Covenant reviews from your governing documents, providing opinions as to the rights and obligations of the association and the board in the operation, dealing with violations, covenant enforcements, collection of unpaid assessments, contract negotiation, litigation of various aspects, construction defect, contract defects, failure to perform, situations such as that. Anything that you can think of that an association deals with from a legal perspective, we're there to provide that assistance. We are almost half the attorneys in the firm are board certified by the Florida Bar as experts in the field. And the reason that only half is that the other attorneys are more involved in the litigation side of the firm, so that was a different type of expertise. But almost all of our general association attorneys are board certified at the present time, which is significant because there's less than 200 in the state.
Wow. Let's go to we've got a caller, Danielle from Coral Springs. Hi, Danielle.
Hi.
You have a question for Robert?
I do. Hi, Robert. So I'm in the industry of community management, and I have a question for you regarding the new legislation that passed on July 1st for the collections. obviously we've all received different various opinions with the new collection procedures and having to now notices written specifically to what the state has now dictated. And the question is how effective do you think it's going to be, considering that a lot of the systems that the management companies use are not able to comply? And I've also heard now that we also need to complete affidavit of notices for each one of our letters that's also mailed as well. So it's a lot of additional time and labor work on the management companies. And then are we even going to be able to comply? And do you think that it's going to change next year?
Well, for those listeners who aren't familiar with what Danielle's talking about, there was a change in the legislation adopted this year that added certain requirements to the collection procedure. Most notably, there has to be a first notice of a 30 days that comes from the association or through its management company prior to being able to charge anything for attorney's fees in the collection process. All associations are required to send this first 30-day notice to owners of their delinquency, and then have an affidavit that it was mailed. And there's specific requirements of where it's supposed to be mailed if the owner doesn't live in the property. And so that's slowed everything down. In addition to that, condominiums are now required. Their first notice of intent to lien has gone from 30 days to 45 days, and their second notice also has gone from 30 to 45 days. So the collection process has been lengthened, 30 days for homeowner associations and 60 days for condominium associations, just to get to the point where the association would be in a position to file a foreclosure case. Whether or not management companies can comply is also problematic, because it does impose a lot of responsibility on the managers and management companies for the associations, and for which there is no ability to pass the cost along to the individual unit owner. The associations are going to have to absorb these added expenses, if there are any, by their property managers. I think there's a lot of concern throughout the state of these new requirements, and we anticipate there's going to be an effort to either revise it or eliminate it. Unfortunately, the way this came about was that the president of the Senate was annoyed with his own community for the way they handle collections, and pushed this through as a personal desire of his. And so the whole state is now dealing with this because the president of the Senate didn't like the way his community did collections. And it is an unfortunate result, but it is the state of affairs that we have to deal with right now. Did I cover it all enough for you, Danielle?
You did. It's just one of those situations where I think we're all kind of starting to pull our hair out. Also, do you feel that, say we started a collection with an owner, condo or HOA, prior to the July 1st change, do you feel that we have to restart the process? That's been some of the opinions coming in. I think it's just to be extra cautious, but I also feel that in some of them, we've already started the process 40 days or 30 days ago or 15 days, before the first, and they don't want, some of these associations don't want to have to renotice again. Do you feel like we have to renotice again, or do you think that we can just use our notices from prior to the change and move forward, or do you think that's going to be arguable?
Well, that's a big question that we've been wrestling with as well, because we do have many matters that are pending with us that started before July 1st. Any new matter that began, that was ready to start as of July 1st, we put the brakes on for everybody. We had sent out a notice in early to mid-June suggesting that our clients start the process, if they wanted to do the collections, to start with their 30-day letters in June if possible. But it took some time to get them set up and operational. So for the most part, most of them didn't start until July. Existing cases, the state of the law when the case began was the state of the law, and that's the legal argument to be made. the real issue on the initial 30-day letter is whether the association is going to be able to recover its attorney's fees, not whether or not it could pursue its claims. So that's really the main risk if a court decides that it had to comply even after the fact, which is unlikely, but it is a possibility in some courts. We're just going to have to wait and see how that plays out.
Perfect. I appreciate it.
Thank you, Danielle.
Right, Danielle. Thanks for listening.
Let's take another call from Douglas in Vero Beach. Hi, Douglas.
Hello, Robert. Hi.
Hello,
Thank
Douglas.
you for doing this. Great community service. I actually have 3 different questions. We're a fairly new HOA, and I'm participating in developing or reviewing the governing documents and updating them. I've heard mention in some of these type programs of something, I might get it wrong, but I believe they called it Kaufman language. The idea was to insert it into the declaration to help give longevity to our documents. It's something that recognizes that the statutes we're citing might change from time to time. And I didn't know if there's a specific phrase or paragraph that should be inserted into the language, or is it as simple as putting in the phrase from time to time might be as might be amended? That's my first question. Is that you follow me?
Well, Douglas, the term Kaufman language refers to an old case that was decided by the Florida Appellate Courts, Kaufman versus Scheer, and it's a lot more complicated than you have described it. But in essence, without having this specific language in your documents, whatever laws were in effect at the time the documents were created and recorded in the public record is technically the statutes that apply for the life of the community, unless there's an amendment or a change in the documents themselves. One such amendment would be incorporating this phrase as amended from time to time when you're referring to the specific statutes that are in place and governing the operation of the community. For a homeowner association, it would say it's governed by Chapter 720 of Florida statutes as it may be amended from time to time is the key phrase that you want to have in order to do that. There has been some relatively recent case law that has resulted in some rethinking of whether it's a good idea to just have a blanket provision for the entire set of documents on the Kaufman language as it being applicable to everything. Sometimes the changes in the statutes are less desirable than others. So there may be a different approach in inserting it in various places where you want it to be and leaving it out of places where you wouldn't want it to be. In a homeowner association, it's less problematic than in a condominium association so far, but you never know what the legislature is going to do from time to time. So each community is going to decide that issue on its own. So when you're looking at changing your documents, you should be having communications with your association counsel and deciding whether or not a blanket one is the best approach for you or whether it's better to do it in a piecemeal basis.
Yes, sir. I do intend, and of course we will run it through a council, but in order to try to minimize costs, I'm trying to get them in as good a shape as possible as I can. Could you spell for me Kaufman versus Scheer so I could perhaps try to find that?
It's Kaufman versus Scheer, Shere.
E-R-E. And did you say that was in a Florida Court of Appeals?
Yes. And it goes back into the, I think, early 1980s or late 1970s. So you just put in that search term and it'll pop up on a Google search.
Terrific. Again, I'm happy to go look that up. Sounds interesting. May I turn to
We can
next
do one more
issue-
question because we're running late for a break. One more question.
Okay, and I can call in another time. I have a concept I'd like to inflation-proof our governing documents. I ran across this in a property we have in another state, and I thought it made a lot of sense. Personally, I've seen how particular dollar amounts that get inserted into declarations and the like, because of the power of inflation, lose their value even at 2 and 3% inflation rates. So I have some language that I am inserting into the declarations, not clear, which empowers the board at its discretion to update certain articles, the dollars amounts, periodically based on a particular index of inflation. My question is that would it be sufficient to include that power in the declaration itself, or do I need to chase that through into rules and regulations or some other, maybe a resolution? Any thoughts, please?
Well, generally speaking, if you're putting it into your declaration, that's going to give it the most impact, but it also makes it the hardest to change because it takes a vote of the owners to do that. If you're putting something into rules and regulations, then the board can likely change that on its own down the road, but that might be making it easier to change than you have in mind. So that might make it more desirable to put it in your covenants. I'm not entirely sure exactly what you're referring to with the specification, but between the two, I think that's the guidelines that you do. Now, when it comes to preparing proposed amendments, thinking it's more cost effective to write them out yourselves, in my experience, it's actually the opposite, because when lay people are trying to do this, it makes it more complex and involved for the attorney to try and get that and fit it into the documents correctly. I find that for my practice, I work much more efficiently when I have concepts that the board's trying to accomplish rather than their attempt at specifying the language that they want to put in. Because unless they're lawyers drafting it, individuals can write things up in a way that might be a little more vague and ambiguous than you want in documents, which creates problems on enforcement. And then we end up having to rewrite a lot of that anyway. So just a suggestion with respect to that.
That's a fair point. I appreciate it.
Thanks, Douglas.
Well,
Thanks for listening.
Thank you, guys. You bet. My pleasure. Thanks for doing it. God bless you.
So we're going to go to break, and that sounds like a new board put together.
Yes.
I should make sure that Kaye Bender Rembaum, and this is mostly what you do, and you cover
That's right.
You just about cover all of Florida.
We have many Vero Beach clients out of our Palm Beach Gardens office.
Great. So give everybody your phone number.
Reach us at 800-974-0680 or go to kbrlegal.com, or you can write to us at info@kbrlegal.com.
Great. We're going to go to break. When we come back, we're going to talk about the calendar.
Yep, we had
We'll
some
be right
upcoming
back.
things.
Kaye Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC, covering South Florida.
We are back. This is the first Thursday of the month, and it is our biggest show. It's been our biggest show for the last 4 or 5 years. It's our community association show. We have had the same law firm, Kaye Bender Rembaum, since, I guess, almost since day one. And people love, first of all, they love the advice they get. And, it's a firm that you can trust. They've been doing this for a long time. They're one of the largest. Again, Kaye Bender Rembaum. And what I like about them so much is they give so much back to the community with their calendar of events, a lot of educational programs, which Robert Kaye is going to go over right now, what's coming up this month.
Okay, well, this month is not as busy as some of our other months, but there is some good stuff coming up. Next week, on August the 11th, at the Signature Grand in Davie, there's going to be a trade show from CAI in the Southeast Florida chapter, and we're putting on two presentations there at 9 a.m. to 10 a.m. Is jumping into the present, why updating your governing documents is important. Emily Gannon of our Pompano office will be presenting that topic, and there is continuing legal education credits for that. Then at 2:30 to 4 o'clock, as 2021 Florida Legislative Update, which is the changes from 2020. We're not up to the most current updates yet. The state doesn't allow us to teach those until after September. So Michael Bender will be making a presentation along with Travis Moore, who's a lobbyist for groups of concerning community association. That's at 2 o'clock to 4 or 2:30 to 4 o'clock. These are both at the venue at the Signature Grand in Davie. Then on August the 17th, on a Zoom, we have a Condominium Association board member certification. That will be by Allison Hertz. That's at 5:30 to 7:30 p.m. And then on August the 19th, also via Zoom at 5:30 to 7:30 p.m. is the Homeowners Association board member certification, and that will be given by Emily Gannon. Both of those are going to be hosted by tskmarketing.com. To see what we're doing in the coming months, go to kbrlegal.com, click on the calendar, and any of the events that pique your interest, you certainly can register for. All of them should have some pre-registration, particularly the Zoom ones, so you can get the information on how to log in. We have some things coming up in September, and then in October we have some more expos. So there's a lot coming up in the coming months.
Okay. Hey, let's go to our phone lines. Let's go to Manuel in Sunrise. Good evening, Manuel.
Hi, guys. Good afternoon, good evening. Thank you for doing this. I have a quick question to Robert. Regarding board candidacy, I know that the statute for a condo, it says that a board member needs to have good moral character, I believe is one of the things that the statute specifically says. Taking off of that interpretively, could a board require its candidates to run for the board, go through a background check for submission? Because we don't know anything about the people that are running for the board?
Well, there is some qualification requirements that there not be any felony convictions in the background. So some of our association clients do background checks on their board member candidates to make certain that there is no such issues in their background. Many do work on the honor system, and if it comes to light later that there was a felony conviction and rights weren't restored for more than 5 years, which is the way the statute limits it, that person would be disqualified from service on the board. Uh, but it's not a commonplace thing that associations tend to do on all of their candidates.
Could it be implemented somehow? And if so, what would be the road to doing something like that? I mean, is that doable?
It is certainly doable. The board can adopt a resolution to make that part of its election procedures each year, that all candidates submit to a background check for the limited purpose of uh, making sure that there is no disqualifying aspect in their background, primarily being no criminal conviction of a felony that has not had their rights restored for at least 5 years.
Okay, so and only at that level. In other words, it has to be felonious of
Yes.
something like that.
Correct.
Okay. Thank you, Robert. Thank you guys for doing this.
You're
Appreciate
welcome.
Yeah, thanks for listening.
We have a line open now at 888-565-1470 if you have a question for Robert Kaye. This is our HOA, our condo, our community association law show. If you're a board member, if you live in a condo and you are at HOA and you have a question, please give us a call now. 888-565-1470. We also have people that email us, and we have gotten a lot of emails this time, and I want to make sure I get to some of them who've said they're going to be listening in the car. We have Faith from West Palm Beach. She said, we are an HOA with 249 units. Does any of the board members have more authority than others? And then the other part of her question, Robert, is if there is a board of 5 members and it goes below 3, what are the consequences?
Okay, so first question being, does any board member have more authority than any other? The basic structure of a HOA and a condominium board is that the board is elected by the owners, and all of the board members have the same powers and functions. They attend board meetings and they vote on board issues, and each of them have one vote. Additionally, there are officers of the association, which typically are appointed by the board at its first meeting following the election. There are some homeowner associations that we're aware of that actually elect their specific officers when they elect their board members. That's an unusual set of circumstances, and it has its own problems that we don't have to get into specifically here. But in general terms, in answering Faith's question, board members are generally equal in their power and authority, and then the board members will vote to appoint from, typically among themselves, officers that perform those specific duties. And you think of it as wearing different hats. When you're making decisions as a board member, you wear your board member hat. When you're making decisions in your officer position, then you're wearing your officer hat. And they're different. The officers deal with the day-to-day operation of the association. Board members deal with the policy decisions, the larger scale decisions of the corporation. When it comes to the issue of having less board members than you need to establish a quorum, you're unable to operate if there's less than a quorum of seated directors. If you have a 5-member board and you have resignations so that you only have 2 left, those two cannot operate because since there are 5 seats, your quorum is 3. So the only thing those two can do is appoint another director to fill that third slot so they can reach a quorum, and then they can appoint to fill the other vacancies as well, assuming you have people willing to serve. If you cannot find anyone willing to serve and you only have 2 directors on a board of 5, then pretty much the operation is going to come to a standstill. No decisions can be made. An owner can apply to the circuit court to have a receiver appointed to operate the association in that instance. But that's something you want to avoid if you can, because that can be very expensive for the association, because the association has to pay the receiver an hourly charge, and their hourly rate is $250 or more. And the courts routinely grant them whatever it is they ask for, and they can spend whatever they choose and charge however much time they take. So that can run into the tens of thousands of dollars to operate your association. So it's important that you have enough people willing to serve on the board. The other alternative is to amend your documents to reduce the size of the board, or allow you to reduce the size so that instead of 5, then you got 3, and 2 is a quorum of 3, so you can function. But as long as there are 5 seats, you need at least 3.
Okay. Before we go to our phones, I want to get someone to text us. Are you getting many phone calls from your clients asking you if they can mandate masks?
We are. There is that question coming up quite a bit. And sometimes people are confused because, as we know, the governor has always been opposed to mandatory mask requirements, and the legislature has imposed certain limitations in Florida on mandatory masks. But that doesn't apply in the private setting that is a community association. If the board, in its reasonable judgment, determines the need to compel requirements of mask wearing in certain common areas, they have the power to do that. Whether it makes sense to do that is another question, and the board has to decide if that's in the best interest of the community. Part of the problem there is how you enforce it. And if you don't enforce it uniformly across the board, then you're creating defenses when you try and enforce it against others. So what many of our clients are doing is making it more a strong suggestion than mandatory. And then hopefully people will use their best judgment when it comes to what they're doing on the common facilities.
Okay. Let's go to Bonita in Coconut Creek. Good evening, Bonita.
Good evening. Robert, I have this following question. Our community, our HOA community, has in place a rule against renting like Airbnb, VRBO, etc. Short-term rentals. We require annual leases, and we've incorporated and adopted that in our documents. My question is this. With the about a year ago, I came across a website called Swimple, where you can rent your backyard and your pool on an hourly basis for parties and things. And at the time, in the whole Coral Springs, sort of North Broward area, there were only about 3 houses listed there, that were doing this. So I felt kind of comfortable that it probably wouldn't catch on. Now I go back the other day, and there's about 48 homes in our area, not in our community, but within the area, that are renting their backyard and pool by the hour. And my concern is, if we already have something that says you can only rent annually, does it have to also include annual backyard and pool?
That's an unusual one. We've not really seen that in a widespread basis, but I think the concern that would come to mind is that your restriction is on leasing the entire home and not portions of it. What you'd be more looking at in this setting is operating a business out of your home, If you're renting out a portion of your home for an hour or two at a time, that's a commercial venture. And if your documents prohibit the operating of a commercial venture out of the home of that nature, if they don't, then you might want to put something in there that does provide for that. And then you can have an appropriate exception for circumstances where people are working from home in a way that's not intrusive or obvious to others. But when you're renting your backyard for parties, obviously you're having a large number or a greater than normal number of people coming and cars and traffic. And so it's relatively obvious and a nuisance to the community. I don't think it falls under the same category as your lease restriction, but there is things you can do from an enforcement perspective. The other problem is by the time you can actually do enforcement, the violation is over. So it becomes a little more problematic, but there are ways to deal with that in the enforcement process.
Should we just add it to our rules and regulations?
You can certainly add it to your rules, but you have to be careful whether or not that's going to be in conflict with your specific restrictions in your covenants. It's always better to put it in as an amendment to your declaration than it is to just shoot for a rule, although it's easier and faster to do it by rule. And it really depends on how your documents are written as to whether or not that would be the best approach.
Okay, so this hourly renting is basically a commercial operation, and we need to look in our documents to make sure we're already covered.
Correct.
Thank you very much.
Good question, Benita.
Well, thanks for calling.
Thank you.
We're going to go to break, our last break, and we come back. We have a line open now, 888-565-1470. Give everybody the phone number, Robert, at the office.
You can reach us at 800-974-0680. Write to us at info@kbrlegal.com. Just go to the website, kbrlegal.com, and you can contact us there as well.
We're going to go to break. We'll be right back with the final 15 minutes of our show. Again, we have a line open, 888-565-1470. We'll be right back.
Kaye Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC, covering South Florida.
We are back. This is the first Thursday of the month. This is our biggest show. We are so lucky to have Kaye Rembaum. And I got to tell you, if you're a board member, you're a management company, I'm telling you, this is one of the largest in South Florida, and we get so many compliments on them. And it's just a wonderful firm, and they really believe in customer service. And how long have you been in business, Robert?
Well, we're coming up on year 30.
Wow. You got to be doing something right when you're in business for 30 years. Let's go back to our phone lines. Barbara in Lakeland.
Hi, my name's Barbara.
Oh,
I have
okay.
a question.
They spelled it
Well,
wrong.
in certain places, it's Barbera.
My no, Barbara. I have a question. We own a property in a community from 2008 that went bust. We were one of the purchasers of a model home, and the development went bust. A couple years into owning it, a new developer came in and built up the community. Now, I know I'm part of that HOA because I bought into that, but the HOA is now changing. Once it transitioned from developer to homeowner, the homeowners went in and changed their documents, not allowing any short-term rental in this community. But that's the purpose we bought it for.
Well, unfortunately,
And,
the Florida. I'm
ahead.
sorry. Go ahead.
Well, my
Had you
question
finished
is,
your question?
am I stuck with the fact that the HOA has their own rules and I got to abide by them, period?
If they amended the Declaration of Covenants to provide for this limitation, then the unfortunate answer to is yes. The Florida Supreme Court decided in around 2004, the most recent case on this topic, the purchase within a community that has a governing documents that can be amended, and they are amended, then you're subject to the amendments that are made, unless they're a very narrow, limited issue that you could attack on. And in a condominium, it's different than in an HOA. In the HOA, they just approved and adopted restrictions on HOAs limiting leasing. But if this happened before July 1st of this year, then there wouldn't be a way around it for you. Did that happen before July 1st?
I believe the vote went into effect in July and it was passed. I don't think it was June. I think it was July. The homeowners did a whole lot of changing when it transitioned from developer to homeowner, and that was one of the things they changed. And they're willing, they're not being uncooperative. They're willing to honor my wishes as long as I own the home. My purpose of this issue is I want to sell it, and I want to sell it as a short-term rental, which I think is a little bit of a higher price point in the market. And sounds like I'm not going to be able to, and I just got to let it die with the sale, don't I?
Yeah, I think so, because the way the statute reads now on the limitation is it would only apply to those who voted in favor of it and new purchasers after it's come into effect. So while it wouldn't necessarily apply to you and your use of it, it would apply to whoever you sell it to.
Yeah, my idea was selling it with that as an advertising. Okay, I kind of thought I knew the answer. I was just hoping for some kind of hope. I thank you for your time.
Thanks, Barbara. So,
Alrighty. Bye.
Jack in Pompano wants to know, do you think the 40-year recertification is too long to wait?
Well, I think there's been some talk that yes, it is, but bear in mind the 40-year certification program currently only exists in Miami-Dade and Broward.
Okay.
So any other county doesn't even have that. I think we're likely going to see some consideration of a shorter period before a recertification than 40 years, particularly along the waterfront. When you get a little more inland, you don't see the same level of deterioration due to the effects of the salt in the air closer to the ocean. But it's hard to say whether it's going to be focused on that or statewide at this point.
Okay. Sam in Boynton said, after what happened in Surfside, how should our condo association run our business, especially when it comes to reserves and safety issues?
Well, it's important that every condominium have understanding of its physical components and what condition they're in. And the only way to do that is to hire an independent expert in engineering to undertake a complete study of the building and make sure that everything is as it should be as best they can. Obviously, destructive testing is something you don't want to have to do unless you see some indication of a need. Uh, so every place is going to be unique in that respect. It's important that reserves be fully funded. It's not mandatory for a board to present the issue of waiving reserves every year. That's something that if the board decides they're not going to do, they want to fully fund their reserves, the board makes that decision. It's not up to the unit owners on that issue unless the board decides to present it. So funding your reserves, making sure they're properly calculated for the useful lives of the components and the replacement costs, and periodically updating those numbers is important for all communities to be doing.
Do you think they should retain a structural engineer?
Absolutely, yes.
Okay.
Particularly closer to the water.
Okay. Here's Barry in Hollywood says, can a $400,000 contract be signed by the president without an appropriate vote?
Well, it's hard to know what he means by appropriate vote, but generally speaking, contracts are supposed to be approved by the board. If it's a vote of the board he's talking about, then no, the president shouldn't be signing a contract unless the board has voted in favor of it first. Whether owners have to vote on a contract is unlikely, so I'm going to conclude that it needs a board approval prior to the president signing it.
You know, we kind of talked about this on the mask mandate. Holly and Davey wants to know, what can we do if the board is using selective enforcement?
Well, selective enforcement is a situation where the board doesn't enforce their restrictions or rules or whatever and the same against everybody. And that's actually a defense to an enforcement. If they're enforcing it in one case and a substantially similar violation is not being enforced, that person has the defense of selective enforcement. And with that defense, the association would be unable to successfully enforce that particular restriction against that particular owner who has raised it as a defense. We always recommend to our association clients that they uniformly enforce all of their restrictions against everyone the same way.
Okay. Susan in Hollywood wants to know, how do we get our board to stop kicking repairs down the road, especially after what happened in Miami?
Well, that's a difficult problem because if the board is going to do what the board's going to do, then the only remedy for owners who don't agree with that is to replace them with other board members who will be more like-minded with those who want to do the repairs. It's difficult to bring a lawsuit against your own community to claim that the board is in breach of its fiduciary duty and failing to properly undertake repairs because you have to prove that the board knew or should have known the repairs were necessary and chose not to do it. There is a defense that applies in many of these instances called the business judgment rule, which allows the board to use its best business judgment in making decisions. The court's not going to impose its own view over that of the board, assuming that they were reasonable in their approach. They used the advice of experts in reaching their conclusion, and that's likely going to make it a difficult case for the owners to bring legal action to compel it. So they're left with recalling the board members or at their upcoming election, replacing them with people that are going to do what's needed in their community.
Okay. We have a couple minutes left. I haven't asked you this in a long time, but we've got people out there. We've got board members who are listening and watching the show, and we have people who are thinking about running for the board. Tell people why they should retain a firm like yours.
Well, there are very few firms like ours, but from that perspective,
You're right.
you do need a firm that's familiar with the area of community association. But ours is more unique from the perspective of, as you mentioned earlier in the show, service is very important to the method and the which we operate. All of our emails are responded to in a timely fashion. Telephone calls are responded to in a timely fashion. People aren't waiting weeks and weeks to get their opinions. It happens in the same day or a matter of a day or two, depending on the issue. And familiarity with the area is also very important. I mean, we've been doing this for 30 consecutive years through our firm, and the number of attorneys that we have, our collective experience is over 100 years. So certainly that's
there's our music.
And important factor.
Give everybody the phone number.
Thank you for listening, everybody.
Yes.
It's 800-974-0680. Go to kbrlegal.com or write to us at info@kbrlegal.com.
Travel safe.
Thank you.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.